Thank you. Thank all of you for your testimony. Let me begin, Mr. Zinke, with you, because I do have some, in full disclosure, I've been contacted by a number of tribes that had concerns about the amendment, and so I want to give you an opportunity to respond to that and maybe clarify the issue for me a little bit. It's my understanding that now when the Corps of Engineers is making determinations on some of these matters, that they first determine whether or not treaty rights have been violated without necessarily committing to go through all the rest. If treaty rights have been violated, why would you go through all the rest? Doesn't that effectively spare you the long and expensive process?
Well, that would be an argument of the Willie tribe, but not the
Well, that's several other tribes, too, in full disclosure.
Thank you, Mr. Chairman. That would be an argument, but it has to do with why segregate out coal from anything else. You have an EIS process, and let's go through the process, of which treaty rights are part of it. The matter includes, in this one, and the reason why it was brought up, because it's time sensitive, is that one position of one tribe says that the fishing rights are part of it. Another position from another tribe, the Crow in this case, says that the U.S. government's sovereign promise to them is that not to impede their self-determination. And so the way to get through the process is let it go through the EIS process. Don't make a determination before the process is done. And that's what we're asking, is that I don't really have a dog in the fight about the end of the process, because I'm confident the process will take its place, and I'm confident that a decision will be made based on the facts. But to arbitrarily give a ruling before the process, EIS, is there an impact? Is there not an impact? So is a treaty violation, does it affect the fish? Does it affect the area of historic and traditional fishing grounds? Can those effects be mitigated? And I personally went out to the pier and take the proposed site. On one side, you have a pier that's developed by a larger company. On the left, you have a pier that's developed by another company in the middle of the proposed site. So I think you have to go through the process to determine whether or not it impacts any tribe or the environment. I mean, that's why we have a process. And so I do find objectionable that a branch of the government would give a determination before the end of a traditionally mandated process that goes through. I mean, what if this is a precedent where all of a sudden any agency can arbitrarily go in, and there are water compacts, there are treaties, I can tell you at least 7 of them within Montana, and a determination before it's properly vetted, I think is premature.
Let me just pick up, and let me make abundantly clear to you, if I were just looking on the basis of the project, I have no problem with the project. I think it's probably a pretty smart thing for us to be exporting coal and recognize it takes some facilities. What I want to be very sure of here, and maybe I misunderstand, I want to make that clear, is that, you know, at the end of the day, whether it's convenient for me or not, if there's a treaty that vests the tribe with the certain rights, that's enough for me. I mean, they don't have to go further. If they make that decision that this is in violation of the treaty and that's determined to be true, I fail to see why you would go much further and look through the rest of it. I'm not sure I see the value of going all the way through if at the up front it's determined now there's a treaty interest here and that's there. On the other hand, I want to make sure I understand, because I know you're very good on these issues, and I know Senator Daines is exceptionally good on these issues as well. So I just want to make sure where, again, if you knew treaty rights had been violated, or you thought they had, or the Corps determined that they had, why would you do the other steps?
Well, Mr. Chairman, the treaty rights are interesting, and let's take this. Is 50% are native, 50% are not. So determining whether or not a treaty right has been violated, it is about fish. Really, you have to do an environmental impact statement to determine whether there's an impact or a violation. I mean, that's what the process does. And in a premature, in this case, does it affect the fishing rights, and does it affect this project? Does it affect any of the fish? Is there any environmental harm? Is there any impact on the tribe? Is there any impact on the adjacent lands? That's what the EIS process determines. And so to jump ahead and say, well, we're going to give this ruling on the basis of what? What scientific data do they have?
Now, let me make my point clear, then let's go to my friend. You may be well right. You may be perfectly right on the environment, perfectly correct. I don't know that, and I can understand the point of saying, but if let's say, and I'll give you an example that I was asked about. I'm a very, very strong proponent of the Keystone Pipeline. It's a wonderful project, should have been approved a long time ago. On the other hand, if it's crossing reservation land, whether I think it's environmentally sound or not, and the tribe decided they didn't want to do it, whether I thought that was economically in their interest or not, or in anybody else's, I would say that's a right that they have. That's their land. So they get to make that call. They don't have to be subject necessarily to process. And that's what I'm concerned here, and that's what I want to make sure I understand. I want to make sure whether I agree with what the tribe does or not, that it's right to make its own decision and exercise its interest as it sees it under the treaty. That, to me, is always the paramount issue here. Not whether or not they made the right decision, because sometimes they won't, or sometimes they'll make it on a different basis than economics. It's a sacred site, or it's something else. You know, that to me is a really major concern here, and I just wanted to express that, and again, give you your opportunity to reply.
Mr. and thank you. To be clear, this is not on the area reservation, and it's not as though we're talking about a Crow reservation vice a different reservation area. So the area is off the reservation. You can see the little.
Is it covered by the treaty?
The fishing rights will the pier adversely affect the traditional treaty rights, because there are rights. Right. Half of it is non-reservation and half the rights are reservation. It is the key is, does that terminal adversely affect their rights and access to fish?
And you want that checked by the process?
Well, that's what the process does. The process looks at it, and this is not the first, again, there's a pier to the left, a pier to the right, and this is a pier in the middle. So it's bounded by, and all three piers are not on the reservation. And so from a project level, is that when you develop these things, you have to have some assurity that the process is not arbitrary. And this process was first put in, I think, when I was in high school. So this has been a long, long process. And every milestone, it seems like it goes through a different process. And so what I'm asking in this amendment is, let's let the process that has been tried and proven and consistent, let's follow it through. That process will determine whether or not there's an impact to the treaty.
Well, and to my friend's point, and I want to make this very clear too, and you mentioned this in your testimony, there are often competing tribal interests in situations like this. And we have certain tribes that have coal resources and reserves that they would like to develop. That would be a way out of Navajo or amongst them, but and so being able to get that product to market is something to think about as well here. It just, to me, and the discussion's been helpful, but making sure that the treaty rights remain paramount and that tribes are free to exercise within the context of that treaty their full rights. That again, whether or not somebody else thinks this is environmentally sound, if it's in their territory, if they have a different opinion or economically, that's what I would want to protect and preserve, is their ability to exercise their sovereignty.
Yes, sir, and I agree with you, because obviously I'm sensitive to tribal law and agreements, and these things are very, very complicated, and that's why it was carefully written, so it didn't pit one tribe against another. It didn't pit Washington, the state of Washington versus Montana. It was very carefully written to say simply this: is go through the process. The process has been known, it's been laid out, it's been consistent, and go through that process and let the results speak for themselves. If there is a violation in the treaty, then it will be determined in the EIS that it's damaging the right of the tribe's opportunity to fish, as the other two peers, in that case did not. So, but that's what I'm asking for. But I don't want to pit the Lummi tribe from the Crows, the Northern Cheyenne, and I go to a basketball tournament in Billings, Montana, where all the tribes get together, and I tell you, there's a lot of old rivalries between. It's wonderful. But in this case, the words were very, very carefully chosen to make sure that it isn't arbitrary, that we go through the process.
I appreciate my friend's explanation.
Yes, please.